The adoption of the Charter of Rights and Freedoms in 1982 made Canada a constitutional democracy in which courts, not legislatures, have the final say about rights and freedoms essential in our democracy: freedom of expression, association, peaceful assembly, religion and conscience, along with the right to life, liberty, and security of persons, not to be arbitrarily detained or imprisoned, not to be subject to cruel or unusual punishment, right to equality under and before the law, and many others. But do our courts have final say, since Canada's Parliament and provincial legislatures can pass legislation taking away any of these rights I just read by invoking a clause in the Charter, Section 33, that allows them to proceed despite the fact that the law is unconstitutional? Why would Canada include this provision that undermines the protections of our own Constitution? This question has arisen again because in the recent past, we have seen an upsurge in provincial legislation that blatantly violates our charter rights, from Quebec's Bill 21, which prohibits public sector employees in positions of authority like police, judges, and teachers from wearing religious symbols like hijabs, turbans, and kippas at work, to the Alberta legislature in the early hours of this morning. I mean, the timing of this session turned out to be propitious. In the early hours this morning, passing a bill that marks the second, third, and fourth time in under 2 months the province has used the Charter's Notwithstanding Clause. This time to ban transgender girls from participating in amateur female sports, to prohibit doctors from prescribing puberty blockers and hormone therapy for those under 16, and to restrict schools' rights to use students' preferred names and pronouns without parental permission. Is the current surge in overriding constitutional rights a blip or a sign of our future? How did Canada come to have a constitution that spelled out essential rights clearly, but also created a backdoor where many of them could be taken away? What is currently being done to address this vital issue? What options are there? I'm Jim Turk, the director of the Center for Free Expression at Toronto Metropolitan University, and this evening we have an impressive panel that is going to address these and related questions, and then take your questions. But before I get to that, before I introduce the panel, I want to acknowledge that the land on which I am speaking to you this evening is the traditional territory of many nations: the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis. I also want to thank the Center for Constitutional Studies and Penn Canada for co-sponsoring this panel. And now our panel. Our first panelist is Eric Adams. Eric is professor of law at the University of Alberta. His teaching and research engages many aspects of Canadian constitutional law, theory, and history. Welcome, Eric.
Yeah, great. Thanks. It's great to be here.
Our second panelist is Anaïs Bussières McNicoll. She is the director of the Fundamental Freedom Program at the Canadian Civil Liberties Association, where she manages multiple CCLA litigation files endeavoring to advance the law on fundamental freedoms, democratic rights, and mobility rights. Anaïs is also deeply involved in the CCLA's efforts to challenge provincial governments' increasing use of the Notwithstanding Clause. Welcome, Anaïs.
Hi, Jim. Thank you for having me.
And our third panelist is Richard Moon. Dick Moon is Professor Emeritus in the Faculty of Law at the University of Windsor, and he is co-editor of the latest edition of the Canadian Constitutional Law Open Access Casebook. Welcome, Dick.
Thanks, Jim. Thanks for having me.
Now, our format for tonight is going to involve a conversation with the panel for the next 45 minutes or so, and then we're going to bring the audience into that. If you look at the chat in this version of Zoom is not operative, but if you look at the bottom of your screen, you'll see a Q&A button. It's a box with a little question mark in it. And we invite you, as you're listening to the conversation, if a question comes to mind at any point, just click on that little button and write out your question while you think of it. You don't have to wait till we turn to the audience for questions. And so if you write them as you go along, this is a really knowledgeable, engaged panel. So I'm sure they look forward to your questions, as do I. And we hope you'll have lots, and especially if you have challenging questions. So please write them down as you go, and I'll turn to Ange Holmes when we get to that section of tonight's event and ask Ange, who's the coordinator of the center, to read out the first question. The panel will answer it, then we'll go on to other questions. So we hope you'll take this opportunity to ask interesting and challenging questions. So why don't we begin? Dick, could you tell us what the Notwithstanding Clause is, sort of its structure? And are you aware of any equivalent constitutional override provision in any other democratic country's constitution?
Sure. Thanks, Jim. I hope people will forgive me for reading at least just the very first part of Section 33, which is the Notwithstanding Clause in the Charter. And it provides as follows, and I'll say a bit more about it in a second. Parliament or the legislature of a province may expressly declare in an act of Parliament or of the legislature, as the case may be, that the act or a provision thereof shall operate notwithstanding a provision included in Section 2 or Section 7 to 15 of this charter. Okay, so what does that mean exactly? So what it means in effect is that Parliament or the legislature can declare that a law will operate notwithstanding certain rights within the charter. So if a court, for example, has ruled that a particular law is unconstitutional, or the legislature anticipates the possibility that a court may rule that a particular law is unconstitutional, the legislature or parliament can expressly declare in that law or in a related law that the law will operate regardless of certain rights within the charter, will nevertheless be enforceable. Now, of course, the declaration has to be express, so it has to be clearly stated in legal form. And Section 33 also provides that any declaration made under Section 33 will expire after 5 years. It can be renewed, but it will expire after 5 years, and there'll have to be a new express declaration for it to continue for yet another 5 years. The idea of the 5-year expiry with a possibility of renewal, it appears is meant to ensure ongoing political accountability for the use of Section 33, since constitutionally an election must be held for either the federal government or provincial legislature within a 5-year period of time. Now, the rights that are covered that the legislature can invoke Section 93 in relation to are Sections 2, which includes what we describe as fundamental freedoms, freedom of religion, freedom of expression, freedom of assembly, and so forth. Also, Section 15, the right to equality, Section 7, right to life, liberty, and security of the person, and a number of related criminal process rights are all covered. It doesn't cover, and we'll talk about this, democratic rights, mobility rights, language rights, and so forth. And it's interesting to think about why some are included within the scope of Section 33 and some are not. So that's something we can explore later. Oh, Jim, you also asked me, was I aware of there being a similar provision in any other democratic constitution? And I think the simple answer is no. I may be wrong. There may be out there somewhere. I know the European Convention of Human Rights, for example, includes a clause that permits state members to derogate from those rights, but in emergency situations. So in other words, a very exceptional circumstance, not like Section 33, where it can be invoked as the legislature chooses in relation to any one of these listed rights.
Thank you, Dick. So Eric, can you talk to us, because I know you've written about it, the historical context in which we ended up with this kind of a charter with a notwithstanding clause?
Yeah, and just to piggyback on Dick, it's a unique Canadian feature of our Constitution. And of course, it has a unique Canadian story that got us here. And it really begins with the Canadian Bill of Rights, which some people will remember as the Diefenbaker Bill of Rights in 1960, before the charter exists. Diefenbaker hopes that he might be able to amend the Constitution to bring in a Charter of Rights and Freedoms, but there's just too many politics around constitutional amendment. He can't solve that problem. He goes for the next best option, which is a statutory Bill of Rights. And it says very similar things to our charter. There's freedom of equality, freedom of expression, freedom of association. All of it is more or less contained in a Canadian statutory Bill of Rights, which Parliament enacts in 1960. But there is a problem inherent in the way our parliamentary democracy works. And the problem is this. Okay, one parliament cannot bind a future parliament. So people asked Diefenbaker and the government lawyers of the day, well, you can announce that we have these rights in the statutory Bill of Rights, but what happens if the parliament 10 minutes later decides to forget them or ignore them or overrule them? You can't, in 1960, tell a future parliament what to do. What was the solution to that? Well, they didn't have a full solution, but the solution they came up with was recommended by Frank Scott, a famous constitutional scholar at the time, said, well, put in a notwithstanding clause so that if a future parliament was to derogate or override the Canadian Bill of Rights, they would have to do so expressly. And at least that would act as a kind of disincentive for them doing so. So the Bill of Rights contained Canada's first version of this notwithstanding clause. And interestingly, it was placed there as a rights protecting mechanism to provide a disincentive to future parliaments from overriding those rights. If they really meant it, they had to say it, and that would perform a kind of public shaming function, and we would at least know what we were dealing with. Well, that Canadian Bill of Rights was copied in some provinces, virtually structurally similarly. And Alberta was, I think, the first to do that in 1970. Peter Lougheed became Premier of Alberta. He says, my Bill 1 is going to be an Alberta Bill of Rights. The Alberta Bill of Rights in 1970 contained the same version of the notwithstanding clause for the same purposes. Flash forward to 1981, and we're now in the thick of it in Canada's constitutional negotiations. Would we get a charter? Would we not? We've got almost all the provinces saying they don't want one. Ontario and New Brunswick were the outliers, but the Gang of Eight, which included Quebec and included Peter Lougheed and Alberta, were saying, no, we don't want a charter. We don't want to change our fundamental system of government from parliamentary democracy to one in which courts will now play this role. And the tug of war goes on. And in a dramatic moment in November of 1981, there is a deal. And included in that deal is, yes, the provinces, all but Quebec, will agree to a charter. Sometimes they did so reluctantly, but they were willing to agree to this compromise. But Pierre Trudeau and the federal government had to agree to the compromise of including a notwithstanding clause. And Peter Lougheed and Alan Blakeney, the Premier of Saskatchewan, were really the champions of this idea, but they weren't the only ones. It was pretty widely accepted that, yes, Canada would have a transformation of our constitutional culture, but not a total transformation, because this notwithstanding clause would exist. It would allow, as Dick has so aptly explained, legislatures or parliament to potentially override a judicial decision if they felt that that judicial decision had got it disastrously wrong. And so alongside a charter which guarantees rights and freedoms, you read 32 sections later, you've got section 33, which says, but the legislatures and parliament can have the final word on some of those rights and freedoms.
Thank you very much. Anaïs, could you elaborate a little bit more on what charter rights can be overridden and what, I mean, Dick began that list, and what ones can't, and so people get a little more detailed idea of where we stand?
For sure. So as Dick mentioned, the Notwithstanding Clause can override Section 2 and 7 to 15 of the Canadian Charter of Rights and Freedoms. So that includes freedom of expression, freedom of religion, association, also the right to life, liberty, and security of the person, as well as the right not to be arbitrarily detained or imprisoned. There is also in there the presumption of innocence, the right not to be subjected to any cruel or unusual punishment, and equality rights. I often feel like the best way to show how serious and harmful the Notwithstanding Clause could be for people of Canada is to think of how far it could go. So, for example, a government could choose to criminalize abortion through the Notwithstanding Clause. It could also ban speech critical of people in power. It could ban women from attending school. It could override people's right to a fair trial or reintroduce the death penalty. So those are all examples that are, of course, kind of extreme, but that also show how existential of a threat the Notwithstanding Clause can be to basic human rights and civil liberties for everyone in Canada. And we're going to discuss this today, I feel like recent history shows that the clause is primarily used against minority groups or marginalized groups. It's important, I feel, for everybody to understand that this clause could harm them as well. So it's a political compromise that started as a compromise, but that left a very troubling mark on our society.
There was a sense at the time it was adopted, though, that it would rarely be used. I don't know if one of you want to elaborate on that a little more.
Well, one of the things you see in the debates in 1981 and 1982 is these kinds of thought experiments of, well, if we include the Notwithstanding Clause, what will its impact be? And I think it's fair to say that there were probably diverse views about that, but a very common view. And it's easy to see why they thought this in 1981. Look, the Charter has this immense political popularity. And so if we're including a Notwithstanding Clause, it seemed to them, the framers of the Constitution, that it would be unlikely that a government would be willing to sustain the political costs of immediately overriding it. And in fact, Jean Chrétien made that prediction that this was going to be effectively a safety valve that was never deployed. And Roy McMurtry, another politician with the Ontario government at the time, really thought there's just no way that the Notwithstanding Clause is going to be used to trample rights because it's part of a constitutional instrument with such powerful political legitimacy that it was difficult for them to imagine a world in which it was being regularly invoked. Now, flash forward about 2 weeks after the Charter is enacted, and the Quebec government uses the Notwithstanding Clause almost immediately to apply to all of their existing laws and all of their future laws. And pressed for why, one government politician said, well, it's not a decoration. You put it in the Charter, and Quebec can use that instrument that's in the Constitution as a way to express our opposition to the way that the Charter left us out of the deal. So very quickly, the framework around the Notwithstanding Clause was met with this kind of shocking development, which is that it's not a decoration, it's there. So even if there had been predictions that it wouldn't be used, those very quickly came at least to have to face the reality in which it might be used, and it was used immediately.
And if I can jump in here, I feel like there's a difference though between the invocation of this blanket invocation of the Notwithstanding Clause that Quebec did right after the what Quebec calls their Night of Long Knives versus what's happening right now. I feel like back then it was really a symbolic gesture because the Quebec Premier felt blindsided and betrayed by the way in which the Constitution was repatriated without Quebec's consent, essentially. And so it wasn't made in a way that was aimed at targeting specific minority communities. It really was this symbolic gesture. Unfortunately, though, it did lead to the Ford decision, which I'm sure we're going to discuss. So it has its significance.
But just to elaborate on what you're saying, René Lévesque brought that in and applied it to everything, as I recall, for the reasons you said. And one indication that it wasn't trying to get through something unconstitutional otherwise was the fact that was it renewed in 5 years? I mean, has that applied consistently since then?
Not in fashion. I wanted to add too that to indicate, I suppose, its good faith, the Quebec government also put in place its own charter of rights and freedoms. So signaling that they're not against rights and freedoms per se, but nevertheless, this was, as everyone said, a form of protest. I did want to add one thing to some of the historical context, and I know there were different reasons why different premiers were ambivalent or even opposed to the charter itself, but there was certainly for some an understandable view that courts were conservative institutions and that they might well act in ways that interfered with progressive legislation of different kinds. There was the historic example in the United States of the US Supreme Court granted 100 years ago, striking down minimum wage laws, child work laws, and so forth. So there was a concern that courts were not exactly the progressive group that somehow we've come to understand them as now.
Ironically, there's some indication for that argument by what's going on south of the border at the very moment we're talking.
Well, absolutely. I want to return to that because those who are very much, in support of judicial final say on this, need to think about the ways in which courts might become increasingly politicized. And as we've seen in the United States, not just ideologically so, but highly partisan in character.
So we can come back to that. Well, what's the sort of decisive Supreme Court ruling on the Notwithstanding Clause came, as Anaïs made reference to, in a decision, the Ford decision in 1988. Would the three of you like to talk a little bit about that decision and its implications, because it's really quite important?
Maybe I'll just start off to say how it arose, and then my colleagues can pitch in on what the court decided. I also have an article people can look up on the Ford decision. But you mentioned the omnibus. It's called the Omnibus Invocation by Quebec in 1982. It applies to all laws. They did let the 5 years lapse on that omnibus invocation and use, but the Quebec government and legislature did invoke the Notwithstanding Clause selectively after that. So the Notwithstanding Clause continued to live on in the Quebec Legislative Assembly, primarily around language rights. And so the Ford case arose out of its use in a language rights context. And it arrives in 1988 at a delicate moment that most of us will now have forgotten in Canadian constitutional politics. But the backdrop of Meech Lake is occurring in 1988. There is a great deal of political, conversation around language rights in Quebec in that moment. And it's against that backdrop that the Supreme Court of Canada has to deal with the legality or use of the Notwithstanding Clause in the Ford case.
Eric, given that some of our audience may not have even been born in 1988, could you just give a little more detail about that context in the Meech Lake and what was at stake, so people understand how that had a bearing on what went on?
It all extends again from the moment Anaïs has referred to it, in which Quebec is left out of the 1982 amending story. They don't agree to and consent to the adoption of the charter and the amending formula in 1982. And so there is, through the 1980s, this project about how Quebec might be able to join the constitutional family and give their consent. And that will come with some kind of amendment, is the proposal. And Meech Lake was the first of those amending efforts led by Brian Mulroney's government, in which Quebec would be recognized as a distinct society expressly in the Constitution itself. And in 1987 and 1988, you begin to see the politics and some great support for the Meech Lake Accord, but also some tremendous opposition to the Meech Lake Accord begin to fray at the seams of Canadian constitutional politics. And so when when the Supreme Court hears this case, they are dealing with a kind of a fraying national consensus around this delicate constitutional moment and the gathering momentum of a Quebec sovereignty movement that is starting to get some more momentum through the 1980s because of that 1982 moment that they were left out, and of course would take full shape in 1995 during that referendum. So that's the political backdrop, and I think it did have some impact on the delicate nature of the court's approach to the notwithstanding clause.
So, Dick, would you like to
No,
talk a bit about the Ford decision?
Yeah, I mean, the specific issue in the Ford case concerned a requirement that commercial signs be in French and the prohibition on other languages on commercial signs. So the substantive question was a free speech question, and this applied both to the Canadian Charter of Rights, but also the Quebec Charter, which included a protection of freedom of expression. But as a kind of context threshold issue, the Supreme Court had to consider whether or not the Quebec government had effectively invoked Section 33 of the Charter. And the arguments against the effectiveness of their use, the propriety of invocating it, was first that it was used in this very general blanket fashion. And the court said, no, we can't get into parsing, how general, how specific they have to be. They can, as long as they expressly declare all laws, to be not subject to the various rights listed in the Charter, that's okay. And they don't have to specify particular rights or anything like that. I guess some of the other things were, could it be used in advance of a judicial determination? And the court said, yes, it could. That was not itself an issue. Now I'm trying to think of what the...
So, I mean, what you mean by that is, could a government declare a law beyond the reach of the Charter, even though it hadn't yet been declared unconstitutional?
Yeah. We'll talk about this in a minute, beyond the reach of judicial review, rather than a Charter itself. But that's another...
Sorry. Yep,
not just a semantic question, I think, and rather important. And I suppose... and the court emphasized that Section 33, it was simply a formal requirement. As long as there was an express declaration, that was it. In other words, the court had no role in deciding whether it was reasonable to make use of Section 33. We have Section 1 of the Charter, which permits reasonable limits demonstrably justified in a free and democratic society on the different rights in the Charter. The courts are involved in assessing whether or not those rights are reasonable, those limits are reasonable and justified. But when it comes to Section 33, the court has no role in assessing whether or not there are good reasons to invoke it. Let me add very quickly, lest people misunderstand. Often when people hear Ford in Quebec, they think it's the Ford Motor Company. It was actually Valerie Ford, wool shop owner, who was the litigant, who had, a small sign of some kind on her outside of her business.
I'm glad you clarified, because some people might hear Ford in Ontario, they think of Doug Ford.
Yeah, that's true. But yeah.
Go ahead, please.
I'll just chip in to say what's interesting, I think, about the Ford case is that, we're more than 30 years afterward. It's really the only definitive statement by the Supreme Court of Canada on Section 33. There have been a handful of references to Section 33 in other cases, but all of it just in passing. It's never been the central legal issue since the Ford case. And so, for the last 30, 40 years, Canadian lawyers and scholars have been wondering, is Ford going to stand? Would it ever be revisited? Would the court ever have an appetite to revisit this argument that it says it's just a formality, there's only formal requirements? Or would there ever be a day where the court would be interested in revisiting whether or not it has any substantive review function in the reasoning for the use of the notwithstanding clause, or require some kind of sense of reasonability? Or is it as broad as Anaïs sort of said at the beginning? Could you literally, through the notwithstanding clause, take away any right that's in Section 7 or 15? Or were there any substantive limits that the court might contemplate? I think one version of Ford says no. The only response here is a democratic one. But maybe I'll let Anaïs kind of fill in where Ford takes us.
Yeah, well, thank you. And one thing that's interesting when we read Ford is when we realize that the court's analysis really was on the limits or absence of the substantive limits within the text of Section 33. There was not a broader analysis of whether limits on the use of the Notwithstanding Clause could be found elsewhere in our Constitution and its architecture. So to that extent that this argument may be relevant to the Supreme Court of Canada, well, it's going to be argued in the Bill 21 challenge, which I'm sure we're going to discuss more. I also feel like there are some other open questions left when we read the Ford decision. For example, does the Notwithstanding Clause ban any form of judicial review, even declaratory judgments? In 2024, again, when deciding the Bill 21 challenge, the Quebec Court of Appeal found that the Ford decision foreclosed any form of judicial review so that it completely insulates a legislation from any form of judicial review, including a declaratory judgment, if the Notwithstanding Clause is used. Then a year later, the Saskatchewan Court of Appeal in the Your Pride challenge reached a different conclusion. The court found that the Ford decision does not rule out court's jurisdiction to issue a declaratory judgment, even if the Notwithstanding Clause has been used. And that's a really important question. I often hear people telling me, like, why is that important if the courts can't repeal the legislation, strike down the legislation, but a declaratory judgment comes with a lot of weight for the electorate.
Could you just explain for people who might not know what a declaratory judgment is?
For sure. Yeah, so a declaratory judgment is essentially just a court assessing the constitutionality of a legislation. So declaring that it unreasonably and unjustifiably infringes a charter-protected right. So
even
essentially,
they can't do anything about it.
Yes, but they can't do anything about it. But it still comes with significant weight. And if we go back to the sunset clause that Dick was telling us about at the beginning, the logic behind the Notwithstanding Clause was always that the remedy was going to be in the ballot box. But how can the electorate make an informed decision if they don't know and if they have not been told by the court whether their governments are complying with or unjustifiably infringing their rights? So that's where a declaratory judgment becomes extremely important in the democratic dialogue that we need.
But is it fair to say that the understanding of Ford it was really quite clear cut? If a government expressly, as Dick said, cites Section 33, it's out of bounds for the courts, and Ford has been taken to mean declaratory, even making a declaratory judgment is out of bounds?
Well, I feel like the Ford decision has been taken to mean any form
yes, I'm
of...
describing how it's been taken.
So, but frankly, when we go back into the context of how the question was asked to the Supreme Court of Canada in the Ford decision, I think it would be quite the stretch to take those paragraphs from the decision and to make them mean that any declaratory judgment is out of bounds when the Notwithstanding Clause is invoked.
I mean, it's worth noting this is a pretty thin distinction between what, in fact, is the court's primary remedy in constitutional cases, which is a declaration of unconstitutionality. And so here we have the usual remedy, declaration of unconstitutionality, and now the proposal, and I'm not against this proposal, would be a declaration that the law would be unconstitutional but for the use of Section 33. I certainly understand the value of it, which, as Anaïs points out, hopefully supports greater political accountability in the legislature. These voters can see that there's some kind of problem or issue with this law and perhaps take seriously the government's action.
Just one other small bit before we move on. Many of us in English Canada don't know much about the Quebec Charter, but I think it was really an important part of the story of Quebec bringing its own charter. Anaïs, could you just describe a little bit the similarity or relationship of the Quebec Charter to the Canadian Charter?
For sure. So Quebec adopted the Quebec Charter of Rights and Freedoms in 1975, so before Canada adopted its own. when I was in law school, I was taught that it's essentially very similar to the Canadian Charter. So it protects basic human rights, civil liberties. It goes a little bit further with respect to specific, for instance, the right to privacy is more explicit. The right to dignity is more explicit as well. What's troubling, though, and that may not be the topic of today's conference, but is how the Quebec government is gradually eroding this important piece of legislation to remove important rights protection and introduce new notions of collective rights, which have to be essentially balanced or even take precedence over individual rights. And I'm saying that to highlight the fact that that's one of the problems when you have those provincial legislation that can be amended through a simple majority vote. And that's also one of the main features of the Canadian Charter, which is great, but also a problem sometimes, but which is that it cannot be amended that easily.
So there was the Ford decision in 1988. From then until the last 5 or 10 years, was there much invocation of the Notwithstanding Clause outside of Quebec?
It was used in the Alberta Legislative Assembly in the early 2000s to protect the heterosexual definition of marriage. It was used in the 1980s, late 1980s in Saskatchewan in the labor relations context. There was some sporadic use, and in most cases, either the sunset or legal developments overtook the invocation, and it did not have a lasting legal impact. So it's really the upswing from 2020 on in Ontario, which invoked it for the first time in that province's history. Obviously, the renewed uses in Quebec, Saskatchewan, and now Alberta. And also contemplated uses. I don't think New Brunswick ever went through with it, but the New Brunswick government, before they were replaced, was contemplating use. And of course, I think Mr. Poilievre made it express that if he would have been elected as Prime Minister of Canada, that he would have used the Notwithstanding Clause for the first ever federal invocation by the Parliament of Canada.
Could you share with people what the issue was around which he would have used it?
He claimed that it should be used in relation to a specific Supreme Court of Canada decision, which he would have overridden, about whether or not it was possible to stack consecutive life sentences on an individual who had committed multiple murders. The Supreme Court of Canada said that stacking consecutive life sentences so that an individual would never have any possibility of release was cruel and unusual punishment. There always had to be some at least theoretical possibility of rehabilitation in a Supreme Court Canada case. And so Mr. Poilievre has indicated that he would use it both to bring back mandatory minimums, I think, in a couple of instances, but expressly on that case.
And if I can jump in here, what we're really seeing in the last, I would say, 6 years or so is a normalization of the use of the Notwithstanding Clause. So like Eric mentioned, Quebec has used it and is still using it against religious minorities to ban the wearing of religious symbols for various public employees, against linguistic minorities. And also it's just overly legitimizing the use of the Notwithstanding Clause by incorporating it into Quebec's new constitutional bill, which is a whole new issue. Ontario is trying to prevent education workers from tried to prevent education workers from striking. Alberta is now doing the same thing. And also Saskatchewan to prevent trans youths from using their chosen name and pronouns at school. So it's really like this progressive expansion of the use of the clause, and frankly, it's not always met with the reaction from the population that was anticipated, and that's probably part of the reason why it's increasingly being used, and it's also a vicious circle because the more it's used, the less people are worried by it, frankly.
Yeah, I mean, I think it's worth noting that the Quebec government, in enacting, and now they have a bill proposing greater or further restrictions on religious exercises in public spaces, that there's no question that our courts, given past decisions, would consider those laws to be unconstitutional. I don't think there's any question about it. Now, the Quebec government, though, imagines itself making the case that these are legitimate restrictions reflecting Quebec's idea of laïcité. What we see elsewhere really is more, in many ways, more an indifference to the charter. Doug Ford understands himself as a populist, as reflecting, public opinion, and why in the world should the courts have a role overriding laws enacted by a democratically elected government? And so I think that what we're also seeing is a greater lack of attention, indifference, and that plays into the populist scheme. And that makes it easier to make use of Section 33. Because earlier on, I mean, Eric was giving some of the examples, but earlier on, in many cases, when governments were contemplating making use of Section 33, it was unnecessary ultimately because the courts actually reached a decision that was compatible, with the legislation itself.
Could we,
One of the
we
things,
talked about,
let
go
me
ahead.
just,
Yeah, please.
one of the things I think that concerns me the most is that in the rise of the Notwithstanding Clause, its most recent uses have almost in every instance been also preemptive. So preemptive before a final judicial decision was reached. In that sense, not responding to judicial decisions, but hoping to take courts out of the equation. And why I think that is concerning is that with the absence of the judicial process around rights, we lose something fundamental about rights protection in this country, which is that as individuals, we are, through the court process, allowed to go and tell our particular story of the way that rights impact our particular circumstance. And it's only in the judicial process that we have to listen to those individuals and we have to weigh their arguments with evidence. And it's the government that has to then respond. And they might, that we cannot account for that individual's rights interests for these very important public policy reasons. But the onus then becomes on government to explain those policy reasons, again, with evidence in front of a arbiter, the courts, who are independent and neutral. When we say that only governments will decide where the lines are drawn on the public interest, then the voices and experiences of those vulnerable peoples who do not have access to electoral power get very quickly shut out of the equation. And we never get a record that judicial decisions themselves create to give us an accounting of the ways in which rights impacts matter in their lives. And we have a whole and long history in this country of thinking that majorities always get this balance right. And our history tells us that that is not always true. And when we ignore those peoples and their rights experiences, all of us can regret the gaze of history after the fact. So that for me is a concern.
Jim, I don't know if there's time, but there is a large issue we haven't really talked about, and that is, and we've sort of hinted at, and that is how we understand the operation of the Notwithstanding Clause. Sometimes it's said it lets legislatures override rights, but the other view, which I hold to, is it lets the legislature override judicial determinations of these, questions. So in other words, it gives the legislature the final say about the meaning and limits of particular rights. And if you think about the rights that are included within the scope of Section 33, that makes more sense because in some ways they are more fundamental rights. But of course, when you talk about freedom of expression, we all agree that freedom of expression is a good thing. We all think it should be respected and protected. We just disagree about what it covers and what are reasonable limits on it. Now, of course, again, this all depends on legislatures being accountable in a meaningful way. And that's a real concern is, the decline really of democratic accountability.
But I think the other point was the one Eric was making. There's a difference when governments use the Notwithstanding Clause to preclude the court even dealing with the issue in the first place. Right? What you're talking about is the court makes a determination that a government's bill is unconstitutional, and then the government invokes the clause to allow it to go forward anyways.
And we should reasonably expect governments to explain why they
That's right.
The court's determination.
But the use of it preemptively is a newer phenomenon, is it not?
Well, Quebec used it preemptively in
No, I mean,
1982.
apart from
So,
Quebec, which, I mean, there were political reasons why he was doing, but then more recently, yes, but that,
Yeah.
I mean, the horse left the barn early on preemptive use. So I don't think the court is going to unwind that. Would be my
right.
strong suspicion, and
No.
it would be hard to do so because at what point in the judicial process are you allowed by the legislature to
Yeah.
use the notwithstanding clause? So,
Mhm.
the people that say, well, it should only be used after what? After a Supreme Court of Canada decision, or could it be the Court of Appeal, or what if it's the court next door in the province with the same legislation? It doesn't really work. I think the restrictions have to come politically to how we react to these judgments. And to a certain extent, I'm a big proponent that courts need to retain jurisdiction to be able to give information and adjudicate the impacts on rights, even if they don't have the remedial power to strike those laws down. For me, that's the right balance to hold the notwithstanding clause in.
And I want to get back to that in a little while. What I'd like to do is turn, we talked about Ford. Right now, there's a case going on before the Supreme Court that is going to be the most serious engagement the court has had with the notwithstanding clause since Ford, I think. And it's one that the CCLA is taking a lead in. Do you want to talk a little bit about the Bill 21 case, Anaïs?
Of course, of course. So to give people a little bit of context, Bill 21 is a legislation that prohibits some public servants from wearing religious symbols at work. So for example, judges, police officers, teachers. But it's important to also know that while this challenge is ongoing, this legislation is being expanded to now include daycare workers and school staff. This type of prohibition is a clear infringement of freedom of expression and equality rights, which is probably why the government chose to invoke the notwithstanding clause and to re-invoke it every 5 years. It did a year ago. So the legislation was still challenged by several groups, including the CCLA, and as mentioned by Jim, it's headed to the Supreme Court of Canada. We just got our hearing dates, and it's going to be the week of March 23rd. There are two key arguments that the CCLA is making. One has to do with the notwithstanding clause. The other is more oriented towards federalism principles. So when it comes to federalism, our argument is that Bill 21's goal is to enforce morality or fundamental social values, which constitute criminal legislation that is under the exclusive jurisdiction of the federal legislator. Then the argument that we're making with respect to the notwithstanding clause is that Bill 21 violates Canada's constitutional architecture by limiting the participation of citizens in public institutions. So in other words, we are saying that there must be limits to how the notwithstanding clause can be used, and that those limits can be found in our constitutional architecture as opposed as within the text of Section 33. So we're talking about the principles of democracy and respect for minority rights that extend beyond the right guaranteed by the Charter. They existed before the Charter and from our perspective cannot be overridden by the notwithstanding clause. So we focus on basic tenets of our democracy, such as the doctrine of participation in public institution, which is a pillar of our society that has a constitutional legacy of almost 250 years. So that's a principle that provides that government cannot exclude people from public institutions by prohibiting and punishing their religious practices. So this is a principle that existed long before the Charter was enacted and the notwithstanding clause was enacted. And our argument is that the notwithstanding clause cannot override those principles.
Dick or Eric, you'd like to add anything?
Well, I mean, one of the important arguments, being made, and Eric has made reference to this, is the idea that the courts could still take on assume jurisdiction to make a judgment about whether or not the particular law breaches the Charter, even if this has no legal force. And there seems to be a growing consensus among legal commentators and constitutional academics that this is the way to go, and I wouldn't be at all surprised if the Supreme Court of Canada, agreed. I'm not optimistic about many of the other arguments that are being made before the court to get around this particular bill, this law.
I mean, the argument that CCLA is making with regard to the protections that Bill 21 takes away being part of the constitutional architecture that can't be restricted by a section of the Charter. is the more is the big remedy if it were able to be accepted.
Yeah.
And I guess what you and Eric were talking about is a declaratory judgment saying, well, even though we can't stop this from happening, it's unconstitutional, is a more partial but possible solution.
Yeah, I'm most optimistic about that as
And that's the road that the Saskatchewan Court of Appeal took in its decision, UR Pride, which is a really interesting decision to read. There's a majority and a dissenting opinion, so you can get both sides of the equation. And I think the Saskatchewan Court of Appeal canvassed really the reasons why this might be the path for the future of the Notwithstanding Clause. Because I don't think it's going anywhere. It's going to be a feature of our Constitution, and as Dick points out, it's got some important roles to play in engaging public courts and legislatures in the shared project of rights. The best version of the Notwithstanding Clause, and when I'm feeling optimistic, I take this view that we need a shared project of citizens, courts, and legislatures to be involved in hard questions about rights. And the Notwithstanding Clause might do exactly that by pulling us all into that shared conversation. Not saying this is the exclusive domain of courts, courts will save us, judges know best. Well, the Notwithstanding Clause says we all have a stake in this, and there's some real democratic value in that. But structurally, it has the capacity for tremendous harm. And I think that's hard to deny, because a very vulnerable minority can, with the current view of the Notwithstanding Clause, be subject to immense legal harms perpetrated under the Notwithstanding Clause by avoiding charter rights that might have otherwise protected them. And so, I think we have to live in a constitution that has those positive potentials, but also has the negative potential that some, I think, would be justifiably fearful are gaining momentum.
Before we turn to the, sorry, Dick, did you want to say something?
No, I mean, I agree with everything Eric's just said, but I do want to temper some of what we have to say with, we shouldn't be romanticize the courts and judges. I mean, they are unelected officials who are given extraordinary power, and as long as we think they do a reasonable job, we're comfortable with that. But, there is a history in other places and other moments of courts doing things that are not particularly progressive, and we're certainly witnessing that in the United States at the moment. And so we also want to be careful not to just say, Notwithstanding Clause is a bad thing, we need to get rid of it. Not that we, as a practical matter, could do that, because constitutional amendment is so incredibly difficult, but not be excessively naive about the courts as somehow the answer. In any kind of democratic society, ultimately, we have to look to the legislature to do the right thing. And the courts have a role, but we should be careful not to overstate the importance of that role, but also, the virtue of the court, the virtues of the courts.
Before we turn to the audience, I just want to extend this discussion more generally to talk about possible guardrails that have been considered to help prevent abuse of the Notwithstanding Clause. I mean, one is a proposal, I don't know if one of you could talk a bit about, that Senator Harder has put forward a bill, Senate Bill 218, to put up some guardrails to limit the ability of the federal government to invoke the charter except under stringent conditions.
Mm-hmm. I'm happy to jump in.
Yeah,
Essentially, this bill would introduce procedural safeguards. So the federal government would not invoke the Notwithstanding Clause preemptively. A Notwithstanding Clause invocation would only be introduced by a minister. I believe that a supermajority would be required, and it will also need some kind of explanatory note at the beginning of the preamble to explain why the invocation of the Notwithstanding Clause is deemed necessary. So we're definitely in the world of helpful guardrails that would help limit the ways in which the clause is being used. But it also does something, this bill also does something else, because it opens a conversation at the national level about the Notwithstanding Clause and about ways to limit the damages that it can cause.
Yeah, I mean, it does involve a supermajority as well as a majority of two parties. so that even if one party had a big enough majority that they constituted 60% or whatever is needed, that still wouldn't be enough. It would have to be another party, a majority of another party to go along. So it is an attempt to put pretty strict procedural conditions. Are you aware of any other examples of provinces trying to deal with this in some way of putting up some guardrails?
In Manitoba, there's Bill 50 that has been tabled recently, whereby any law invoking the notwithstanding clause would automatically be referred to the Manitoba Court of Appeal for a constitutional opinion. So essentially a declaratory judgment on the constitutionality of the legislation. And it's also interesting to note that the current Manitoba Premier has pledged never to use the notwithstanding clause.
Now, there is one other guardrail, and none of you has addressed it too much. And the only example I know of it actually working was the invocation, or the invocation by Doug Ford, the Premier of Ontario, when the education workers, that is everybody but the teachers in the schools, were going on strike. And this was an interesting guardrail because what happened across much of the province were protests organized by the Canadian Union of Public Employees, which was the union representing these education workers. And they were massive, and they were all over the place. I actually participated in one, for those of you who know Toronto, at the corner of Dundas and Yonge, and we took over the street. I mean, police were there, knew we were going to do it. And they were so massive that the Premier backed away from it.
Well, I'll add some Alberta historical examples to that list, Jim, because Ontario is not the only place. Alberta contemplated two uses, one that made it into a legislative bill in the 1990s, and the other in response to the Vreen decision. And in both cases, the government of Ralph Klein floated the idea that they would use the notwithstanding clause, and the negative public reaction to those uses had the government step back, and in one case withdraw the bill that had the notwithstanding clause in it, and in the case of Vreen, to abandon the prospects of using the notwithstanding clause. So it's not that the public can't have an impact on the way that the notwithstanding clause is deployed. It's just that it has to be very motivated in doing so, because the governments, I think provincial governments, know that they will have some opposition to using the notwithstanding clause. But in the political calculus, I think provincial governments have started to say, but I think at the end of the day, we might have majority popular support, right, even in the face of some public opposition. And maybe that's the dynamic that is going to depend on the particular circumstance in which it's invoked.
Yeah. I mean, I mentioned the example I mentioned just because when we're talking about guardrails, I think we shouldn't forget popular resistance.
Yeah, I mean, that's not much a guardrail. That's how it's supposed to work, in a sense.
That's right. But I mean, that's what stops it from happening in some cases.
Yeah,
and
but that's about political, that is about the political accountability that we imagine should be in place.
But you have to wrestle with the structural issue, which is that when you're dealing with a vulnerable minority, be it a criminally accused or a highly vulnerable minority, the idea that the public is going to rise up in the streets is not a structural solution to that particular problem. And so many of Canada's immense rights abuses, be it residential schools or the internment and exile of Japanese Canadians, which I've just written a book about, they would not have caused much concern by a majority of the public, and that's the problem. So that
although courts at the time also were willing to sustain these things when given the opportunity.
That's right. And there's a long history of that, both in the United States and in Canada. And you have mentioned the difficulty of amending the Constitution, which would be another solution. But for our readers, for our listeners, I guess the amending of our Constitution is a complex matter, and maybe it's oversimplifying it, but the 70-50 formula that in order to amend it, you need approval from the House of Commons, from the Senate, and from at least 7 provinces representing 50% of the population. So that's a really high bar to get any amendments. So I don't think amendments are likely to be a remedy in any of our lifetimes.
Jim, I should say I'm not against Section 33. I mean, I think it made sense. it's harder to hold on to that the more we see its frequent use and the more we see, or the absence of any kind of public accountability or the public paying attention. But I think it actually makes sense. We start with the idea that unelected judges, given this enormous power, do we want them to have the final say? And it's not obvious. I mean, judicial review is not a sort of straightforwardly good, sensible thing. There are good reasons for it, but it's not obvious and straightforward that judges should have the final say. So I certainly am not unsympathetic to the inclusion of Section 33.
Well, Eric or Anaïs, before we turn to the audience, do you have a general comment on this to make before
Well,
we
one
go?
thing I'd like to say is just to acknowledge that these are really unprecedented times for our democracy. I feel like sometimes, like essentially, not a day goes by without hearing from another attempt by a government to limit rights and freedoms, to shrink our civic space, or to weaken checks and balances. And from my perspective, the growing use of the Notwithstanding Clause is part of that bigger picture and a broader threat to our democracy. And to go back to this point that we were discussing about the importance of people being engaged, it's easy to feel defeated as a citizen, but we should remember that we have the power. Governments are supposed to serve us, and some politicians will listen if we speak up and if we care about our rights, but also the rights of our neighbors.
Eric, do you have a final comment?
Oh,
before we
that's a
turn to the
nice
audience?
last word. So I think just turn it over to questions.
Okay, Ange, do you have any questions?
Yeah, we do have a few questions. So the first question, it actually came from a couple people, and they'd like to know what the panelists' views on the bill in the Senate put forward by Peter Harder are. Do you think that Parliament can unilaterally amend the charter as Senator Harder proposes in this bill? And isn't that quite dangerous? Couldn't other provinces then unilaterally amend the charter to say some sections do not apply to them?
Maybe
So just,
I'll
go
take
ahead.
the first stab at this and say I don't think it is a proposal to unilaterally amend the charter, and of course that would be improper and would not be possible. But there is a precedent, and constitutional amendments is the place for that precedent, where the federal parliament or government says we will not be involved in a power that we might have under the Constitution, but we choose to limit ourselves and the way in which we might use a constitutional power. So in amendments, they say, for example, we won't use the 70-50 formula to amend the Constitution unless amongst those who agree, Quebec, Ontario, BC, and Alberta agree. So they didn't amend the Constitution to make that change, but they did say we are going to restrain our own use of our powers in the context of constitutional amendment. Now, it might be a good idea or a bad idea to have that as a legislative policy of the Parliament of Canada. And of course, that policy could itself be overridden by legislation which took a different view in the future. No parliament can bind a future parliament. So it might be helpful to shine a spotlight on the Notwithstanding Clause to indicate a kind of public position around not using the Notwithstanding Clause, but I don't think it would have the impact of actually structurally binding the government of Canada or Parliament because it can't do so.
Yeah, I mean, just to follow up on that, if this bill were to pass and become law, as Eric says, it could be repealed at any time. Now, of course, it might be awkward, politically embarrassing to repeal it, but that's a political constraint, and so it's not a constitutional amendment in any way.
Anaïs, did you have anything to add?
No, I agree.
Okay.
I agree.
Yeah, so I mean, the notion that this is somehow an attempt to a backdoor way to amend the Constitution, it's not. It's just to it's self-restraint by Parliament is what he's looking for. Okay, Ange, another question?
Yeah, and I do want to remind attendees that you can use the Q&A button to ask questions at this point at any time. Yeah, the next question is from Elder, and Elder says, considering the evolutionary nature of human rights, such as human dignity, can the Notwithstanding Clause be considered unconstitutional if it is used to violate fundamental human freedoms? For instance, when we consider the rights of transgender people, the Inter-American Court of Human Rights has stated that they are entitled to their self-perceived gender identities. Such laws passed using the Notwithstanding Clause would be considered unconventional or incompatible with the Convention if Canada were a party to the American Convention on Human Rights.
Canada, of course, is in breach in international law in, certain past situations. That doesn't bind our domestic courts. It can play a role in how they interpret the charter rights. But for example, it is the case that, as you know, in Ontario, that Roman Catholic schools, separate schools, receive funding when other religious schools don't. And this stems from Section 93 of the 1867 Constitution. And our courts have said until that's repealed, and repealing it would be very simple and straightforward, but until it's repealed, there is nothing unconstitutional about exclusively funding Catholic schools and not other religious schools. Well, the Human Rights Committee under the International Covenant of Civil and Political Rights has determined that Canada, in funding exclusively, in Ontario, funding exclusively Catholic schools, is in breach of the International Covenant of Civil and Political Rights, to which Canada is a signatory. So we are in breach of international law as long as we carry on as we have. So that doesn't directly affect the application and the interpretation of domestic law, our Constitution in particular.
And then I would say in the Supreme Court of Canada challenge, there will be some attempt to reach into constitutional architecture, constitutional principles. Anaïs has laid some of that out to say that there is a deeper normative structure that says that some things, in fact, are beyond the capacity of the Notwithstanding Clause. I guess I'll reserve judgment until the Supreme Court of Canada weighs in on that, but I would be surprised if the Supreme Court of Canada takes that route. I think there's going to be tremendous pressure to hold the line that the court found in Ford, which is that there can be good reasons, there can be bad reasons, there can be no reasons, which would explain why a particular legislature would invoke the Notwithstanding Clause, and that's really not the province of courts to comment on. So I think the idea that there would be some uses of the Notwithstanding Clause that might be constitutional, but other kinds of uses that would be unconstitutional because of the substance of that use, I'd be surprised if the court takes that view.
As you know, the federal government in its intervention, the Bill 21 case, is making the argument that the Notwithstanding Clause cannot be used to insulate some kind of action by a government that would cause irreparable harm to one of the charter rights. I don't see that argument succeeding. I think it's far too difficult for a court to make the determination of how much is too much, when is something irreparable versus when is it just a serious interference with the right in the moment. But anyway, arguments like that are being made, in fact.
Anaïs, do you have any comments you want to add on that?
Well, frankly, since this is something that we're litigating right now in front of the Supreme Court of Canada, I'm kind of limited in terms of what I can respond. So I'll exercise some caution here.
Okay, thank you. Ange, another question?
Yeah, the next question is from Adam. And Adam says, some of the people who are arguing that the Supreme Court should restrict the use of Notwithstanding Clause assert that it was not intended to be used the way it was. Professor Adams very articulately explained the history of this understanding. Many of these same people strongly oppose the use of such original understanding when it applies to other sections of the Charter. Do you think that there is any principled distinction between such arguments about original understanding when it comes to Section 33 versus other sections of the Charter?
I really like the part of the question that said something about very articulate. That was the part that caught my attention. Well, look, I think for me, the Notwithstanding Clause is going to be a product not just of original intentions, which I think there is some evidence clearly that some constitutional framers said that this should be used to empower, legislatures and Parliament to have the final say. That's clearly on the record. Now, I think there's a debate about whether the final say means the only say, which is why I'm not sure that answers all the questions about the Notwithstanding Clause. But I actually don't think that the court is simply going to say, let's take an originalist take on what this means. But the text of the Notwithstanding Clause is very sparse. It does not give many ledges for a substantive engagement with how it's being deployed. And that's why I think in Ford, the court, looking at that text, said, there is not much scope for judicial review here. It looks like a formal set of requirements, and those formal sets of requirements, I think, are in keeping with at least one of the versions of why it was there. It was there to be used by legislatures when they felt they needed to use it. So at any time you start to say, but surely it can't be used in this way, surely they didn't mean it to be used in that way, I think you run up against the very real difficulty of defining what those impermissible uses are, which is I think been a struggle for the court. I think Dick just mentioned, irreparable harm is a pretty tough standard, I think, to try and capture in uses of the Notwithstanding Clause.
Would anyone else like to comment on an aspect of the question? No? Okay, Ange, the next question.
I think Richard was trying to comment.
Oh, I'm sorry, Richard.
Yeah, no, I had my mic off. I don't want to wade into originalism debate because that's a very large question. But the reality is, and I think Eric pointed this, how we understand a particular text, where it came from, is obviously all part of the interpretive process. But different people understand its use, its function in different ways, and the fact that many of the designers or supporters of this clause did not imagine it would be used frequently does not actually change its design, its character, and how it's been drafted.
Okay. Thank you. Ange, another question, please.
The next question is from Carolyn. Carolyn says, wouldn't it be fair to say that we are seeing uses of the Notwithstanding Clause that threaten the very project of confederation, in quotes, if we have, for starters, one provincial jurisdiction that disallows rights that other provincial jurisdictions uphold, we have a potential fracturing of the nation. Do we not? In as much as understand our collectively articulated rights as what bind us together as a nation. Perhaps I feel more worried than others do, but I would love to hear what the panelists feel about the larger political threat to Canada that one or another current use may constitute.
I don't know what comes first, whether somehow the use of it is somehow causing damage to the Federation, or whether or not the sense of, separateness of, say, Quebec or Alberta or whatever is in part supporting and driving the use of Section 33 in some cases. Certainly in Quebec's case, this idea that we are different, we have a different understanding of the place historically, for various reasons, of the place of religion in the public sphere, and we are going to assert that. So I don't know whether the Notwithstanding Clause comes first in causing a greater sense of separation, alienation, division, whatever, or whether or not that kind of cultural difference is already there, and this is just manifesting it.
One thing that I'd add, because I'm from Quebec, is also that the Notwithstanding Clause is giving an occasion for the government to run on a populist agenda, and to essentially give the population legislation it's not necessarily asking for. So it plays into, for example, this trauma, generational trauma that some Quebecers have, older Quebecers have with respect to religion. It plays into that, and then adopts this legislation that some people feel like, yeah, this is good because I'm not comfortable seeing religious symbols, so I'm very happy that I won't get to see them anymore, essentially. But what's important is also that a huge part of the Quebec population does not resonate with that discourse, which is why it's so important for those people to understand what the Notwithstanding Clause is and why it is that governments can just adopt legislation that overrides rights and freedoms, and then they can decide to demand a government that maybe won't use the Notwithstanding Clause. So that's also, I just want to be careful when we talk about Quebec. It's not everybody in Quebec who thinks that Bill 21 is a great idea and who is afraid of seeing a religious symbol.
Maybe I'll just, for my 2 cents, say that federalism is also fundamental to Canada, and it's an expression of the diversity of this place, and I don't think Canada can exist without that federalism. And that might include different approaches to rights across Canada. It might be the best reflection of what's possible in Canada is one in which British Columbia and Prince Edward Island have some differences around the judicial culture around rights, and that might not be a bad thing. That might be one of the ways that we are able to sustain this place. And so some would say that the Notwithstanding Clause is about a further recognition of that possibility of diversity, that the reason we gave that power to legislatures is because a legislature might make a decision to have a slightly different rights outcome in a particular jurisdiction than their neighbor. And that's the stuff of politics, and though that's the stuff of a diverse federation like Canada.
Thank you.
I was going to add too, something that is often sort of in the background, occasionally surfaces, is of course that the judges at the Superior Court, Court of Appeal, Supreme Court of Canada level are federally appointed. And this is sometimes pointed to as itself a problem, that the federal government makes a determination about, who the judges are, who the ultimate decision makers are. Yeah, so anyway, that sometimes is pointed to as a problem. Now, the idea of judges being federally appointed was also seen historically as having the advantage of creating a single unified court system, resulting in, often common interpretations or applications of the law across the country. So in tension with the federal system.
How accurate has that expectation been? Do you notice differences in courts of appeal across the country, for example, even though they're all federally appointed? Hope you're muted. I can't hear you, Dick.
Yeah, no, I mean, there are differences, of course, but, certainly to point to a very different example, the reliance on federally appointed judges in the Deep South as playing a very important role in dismantling Jim Crow at that earlier stage. So there's no equivalent here in Canada on that front, but nevertheless, you can imagine federally appointed judges playing some kind of potentially unifying role. But again, the flip side of that is, well, does that work against the idea of federal diversity?
Okay, Ange, another question?
Yeah, the next question, an attendee asks, what changes in politics have made the Notwithstanding Clause a more significant instrument for government's policymaking, especially since McMurtry, Romanov, and Chrétien have stated that it was meant to be used rarely and as a safety value. Also, Kahana has talked about the ameliorative and tyrannical uses of this clause. Has this clause made Canada a richer or poorer constitutional democracy?
Maybe I'll tackle the first part of that. I think time is an awfully important variable here. I think it's not a coincidence that we're 40 years out of the charter, and the power that the Notwithstanding Clause has changed over those 40 years because of the initial idea that it simply the political costs would be so powerful, especially in English Canada, that it was just really could not be contemplated. And there were some early indications that it might be possible to deploy it in some very specific circumstances, but as the Alberta examples in the 1990s showed, that when Alberta tried to dip its toes into the Notwithstanding Clause, they got a fairly strong rebuke that it would not be popular at some fundamental level. Another 20 years went by, and our political culture has changed. Our sense of what is outrageous has changed, and our distance from the constitutional moment in 1981 has all made the invocation an easier experience. And I think, as Anaïs said, once one use indicates that the sky doesn't fall, once you break the glass doesn't get remade. I sometimes tell my students, the stove seems very hot until you kind of put your hand down and realize that no, it's not that hot. It can be touched. And provincial governments are discovering that the stove can be touched. For a long time, the assumption was it was too hot, and it might be that way in some contexts, but in other contexts, I think we're discovering that it can be used perhaps even to political advantage.
And if I can jump in, I feel like we're also seeing, like, just to echo what Eric has said, this tendency from governments to blame their own policy failures on minority groups. So to identify an enemy, this is a strategy that is as old as times, but to identify an enemy and to try to turn the population against them to detract attention from the government's failures. So I feel like we do have to call out whenever we hear amalgams or shortcuts opposing human rights and civil liberties with so-called collective values or physical safety or other objectives. I mean, history shows that the harms that significant harms can be caused to vulnerable people if majoritarian views are an absolute justification. So it's certainly something that we have to remain very mindful of.
I think it's also the case that I think people are less engaged in the political life of the larger community and certainly of the nation. And this is not helped by the dramatic spread of misinformation and disinformation online. And, I apologize for this partisan statement. I mean, lack of political engagement, how else can we explain the re-election constantly of the Doug Ford government? And I'll say no more about that. That's obviously rather partisan for this panel. But I think that's a real problem. People aren't paying attention and are increasingly indifferent to public action, political action, and to breaches of rights, potentially.
And another question.
Yeah, and Barbara asks, could the panel discuss the relationship between Section 28 and Section 33 of the Charter?
Who wants to have a go at that?
Well, I will say we don't know the answer yet. Section 28 of the Charter says that, and the crowd's got to get ready because I'm going to give you another notwithstanding clause. Notwithstanding anything in this Charter, and the notwithstanding clause is in the Charter. So one possible reading of Section 28 is that notwithstanding the notwithstanding clause, rights are guaranteed equally to male and female persons. So what does that mean? Well, it's received very little judicial interpretation, handful of cases, but none very substantive. It has generally been thought of as an interpretive provision, not as a substantive rights-giving provision. But one possible, maybe even plausible interpretation of it is that it appeared in the Charter in part in response to the notwithstanding clause and the fear that it might be used to roll back the notwithstanding clause, roll back the protection of equality rights in Section 15. And remember, Section 15 is one of the provisions that the notwithstanding clause can be used in relation to. And so the Supreme Court of Canada is going to engage in the Bill 21 case the question of whether or not Section 28 might be used to say, well, you can use the notwithstanding clause in some rights, with some rights impacts, but not where those rights impacts have a disproportionate impact on women. And there's an argument that maybe Bill 21 has a disproportionate impact on women because they are more likely to wear a religious symbol. We're talking particularly about Muslim women wearing the hijab. And there's some evidence that maybe they were the target in particular of Bill 21. And so there is some thought that perhaps the courts will have to wrestle with this argument as well. The Quebec Court of Appeal sort of did away with this argument when they heard the case by saying the notwithstanding clause essentially disappears those rights. And so if those rights are disappeared, then there's nothing for Section 28 to engage with because there's no longer rights to guarantee equally to men and women. That's how the Quebec Court of Appeal kind of got around that Section 28 issue. Is that the way the Supreme Court of Canada will handle it? Everybody is waiting to see.
Yes, and I mean, from my perspective, absolutely no doubt that Bill 21 disproportionately targets Muslim women. So I feel like this argument about Section 28, which of course is part of the Bill 21 challenge, is extremely important to the conversation.
And another question.
Yeah, the next question, somebody asks, do you think that the notwithstanding clause entrenches democratic values because it gives the people the power to determine the scope of charter rights and to overrule the court's interpretations? Or does it just entrench populism, as Anaïs is eloquently hinting, and raise questions about our views that democracy is always good?
Well, it does both, I guess. I
You
think
want to
that's,
elaborate, Dick?
well, no, in the sense that, as we've talked about, the original vision was the idea that courts shouldn't necessarily have the final say. Because they're an unelected body, and we may have concerns about decisions they could reach in different situations, and so it makes sense. And this all fits in with what some people, Peter Hogg in particular, describes the dialogue model, where the court make a judgment, the legislature might disagree with it, and they could potentially overrule the court's determination and so forth. And that could be seen as democratic. I mean, a democratic system is one that respects rights, of course, but is about, elected officials having a significant role in making law. But as we've talked about, as our concerns about democratic accountability grow, we begin to wonder about the place of Section 33 and whether or not it really is going to play an increasingly large role in undermining fundamental rights, which are also an important part of our democratic system or structure.
Eric or Anaïs, do you have anything you want to add?
No, it's well said by the
Okay.
esteemed Professor Moon.
But not articulate, just
Well, I'm afraid we're at the end of our time. I want to thank the panel for a really engaging discussion of what could be a complex issue in which people get lost in the weeds, but I think all three of you were remarkably clear, and I found it a very, very informative conversation. Thank you very much. And I want to thank the audience for coming and listening and for your engaging questions. I think they really added to the value of this conversation enormously. The video of this panel will be posted on the Center for Free Expression website tomorrow. So if any of you who've listened to it would like to recommend it to others, they can have access to it. As well, we post along with the video of this a separate link to additional readings and resources, which will be many of the cases or other writings that panelists have mentioned tonight, or other things that they think someone who wants to dig into this matter a little further can read. So we'll put up copies, links to copies of various papers, court decisions, and other kinds of things that I hope you will find valuable. All that is on, as I say, is on the CFE website, which is cfe.torontomu.ca. Also, you'll find there information about our upcoming events, as well as links to the videos of all our past events. So I hope you'll take advantage of this wonderful set of resources. And again, thank you to the audience, and especially thank you to the panel for tonight. Good night, everyone.
Thank you so
Thank
much.
you.
Good night.